believe both counsel are here. Good morning, Mr. Culpepper. Good morning, Mr. Hansel.
Good morning.
And I will formally call the case number 68, Anne Arundel County, Maryland versus Rodney Price versus Michael Reeves. So we'll begin with your presentation, Mr. Culpepper.
Thank you. May it please the court, Philip Culpepper on behalf of the petitioners, Anne Arundel County, Maryland, and Officer Rodney Price. This case gives the court an important opportunity today to apply the law to a judgment below that erroneously awarded more than 25 times the amount of damages allowed by the legislature for the recovery of the wrongful death of a pet. Pet owners, like the respondent, like myself, and I'm assuming like every member of this bench that owns a pet, we tend to think of our pets as something more than ordinary household chattels, perhaps as members of the family. But sometimes the law is in conflict with the heart, and this is one such case. There's a law in Maryland that caps the total award of compensatory damages due to an owner of a pet that is tortiously injured or killed. It's Maryland Code Courts and Judicial Proceedings, Section 11-110. This is a statutory cap on damages, just like its counterpart found 2 sections earlier in Section 11-108, the cap on non-economic damages. By its plain language, Section 11-110 provides that compensatory damages that are due to an owner of a pet that is tortiously killed cannot exceed $7,500. Today, of course, the cap is $10,000, and at the time of the underlying facts in this case, it was $7,500. Section 11-110 also defines the type of compensatory damages that are available for the death of a pet. It expanded the common law remedy for injury to property by allowing an owner of property to recover both the fair market value of the property and the reasonable and necessary veterinary costs. No other type of compensatory damages are contemplated by Section 11-110, and all efforts to amend the law in the past to provide for other types of damages have been unsuccessful. Yet, despite the clear and unambiguous language of Section 11-110, both the trial court and the Court of Special Appeals below declined to apply it to the judgment in this case. They did so because of the Court of Special Appeals' prior opinion in Brooks v. Jenkins, which is the only reported Maryland case interpreting the application of Section 11-110. Brooks held that Section 11-110 only applied to damages arising from the injury to a pet and not to any of the other damages that might have been suffered by a pet's owner. In that case, the other damages the court was talking about were the violations of the pet owner's constitutional rights. Brooks reasoned that Section 11-110 does not and cannot alter the fundamental nature of the underlying tort. But even if that's true, the Brooks court reached the wrong conclusion because the fundamental nature of the underlying tort in that case was an injury to a dog. The dog's owners alleged a variety of theories of liability arising from the injury to their dog, including claims that their constitutional rights to be free from a deprivation of property without due process were violated. But 30 years prior to Brooks, this court, in answering a certified question from the United States District Court for the District of Maryland, held that the remedy for a violation of the Maryland Constitution is a common law action for damages to trespass. That is to say, when a property is wrongfully destroyed by another, its owner can bring a common law trespass action for damages, or a constitutional claim for its deprivation, or both. Regardless, the remedy is the same for each. And because of Maryland's one wrong, one recovery rule, it was error to find that there were some other types of damages due to the dog's owner above and separate from the injury to their dog.
Mr. Culpepper, is that cite in your papers, in your pleading?
Yes, that is Widgeon versus Eastern Shore, and it's in the brief. The very same.
One more question, if I may. So if we were to find in your favor, is it your position that we would have to overturn the Brooks case?
Well, its effect would be if you reverse the Court of Special Appeals here, in effect, you would be abrogating Brooks and making it not good law because Brooks was wrongly decided for that reason, finding this extra damage above the injury to the dog. The same analysis is applicable here because all the jury concluded at the end of the day, in this case, is that the respondent's dog was wrongfully destroyed. The only injury the jury assigned any monetary value to arose from the death of the dog, and nothing else. Section 11-110, even using the rationale posited by Brooks, should limit the total award of compensatory damages to $7,500. This court has held that statutory caps on damages abrogate causes of action for amounts in excess of caps and remove the issue from the judicial arena. And that's why this court should reverse the Court of Special Appeals here, abrogate Brooks, and direct the trial court to enter a judgment in an amount no more than $7,500. Now, the petitioners in this case, of course, are asserting that there is no ambiguity in the plain and ordinary language of Section 11-110 when it says that a person who tortiously kills a pet belonging to another shall be liable to its owner for fair market value and reasonable vet costs not to exceed $7,500. But to the extent that there is any ambiguity in the text, as this court knows, a foray into the legislative intent might be necessary. So first, it should be noted that when this law first came into existence in 1989, it did not include a definition of compensatory damages. It just declared the measure of damages for injuries to a pet are the fair market value or the reasonable vet costs, whichever is greater. That was an expansion of the common law remedy for damage to chattel. And the compensatory damages definition was not added until the 2005 amendment. And in the 2005 amendment, the legislature for the first time provided a definition for compensatory damages that were to be available in this situation: fair market value and reasonable and necessary vet costs. In so doing, the legislature stated expressly that its purpose was to establish liability for certain compensatory damages. Now, a pet owner could recover both types of damage rather than whichever one was greater. Maryland has long accepted the doctrine of expressio unius est exclusio alterius, or the expression of one thing is the exclusion of another. So by expressly listing the types of compensatory damages available, the legislature was intentionally excluding other types of damages like mental anguish, loss of companionship, and other so-called non-economic damages. Compare the text of Section 11-110 to the Wrongful Death Act found in Section 3-904. The Wrongful Death Act expressly provides for compensatory damages including mental anguish, emotional pain and suffering, and loss of companionship. The same is true for personal injury found in Section 11-108, or drug dealer liability found in Section 3-1601. When the legislature wants to provide for non-economic damages, it knows how to do so. And when it expressly listed only two types of damages, it did so at the exclusion of the recovery of all others. The legislature is fully aware that Section 11-110 provides recovery only for fair market value and reasonable and necessary veterinary costs, but you don't have to take my word for it, because you can hear directly from the sponsor of House Bill 992, who testified earlier in February of this year before the COVID-19 shutdown at the House Judiciary Committee in support of a bill to increase the cap from $10,000 to $25,000. And in his opening remarks, he said, "There's currently a cap of $10,000 on real damages. It is not adequate to address the actual costs suffered. I would personally like to eliminate any cap to damages, and I'd also like to put in something like non-economic damages." You can find a link to that testimony in our reply brief on page 4 in the footnote. It's absolutely clear that Section 11-110 does not provide for the recovery of non-economic damages or any other damages at all other than those expressly listed. And that's why it should be applied here to limit the judgment. One of the other factors that should be considered.
Mr. Culpepper?
Yes, Your Honor.
Yes. It's reasonable to assume that the legislature is also aware the Court of Special Appeals is holding in the Brooks case, but it's never acted to enact legislation to overrule it or abrogate it in any way. So would this be or lead to a fair inference that the legislature intends the statute to cap only those types of compensatory damages described in the statute?
Well, as this court has pointed out many times, the knowledge of its decisions to be known by the legislature is a useful fiction. And I point out to this court that the cases cited by the respondent on this very issue all concern opinions from this court, the Court of Appeals. And Brooks, of course, was from the Court of Special Appeals. And we could presume that perhaps the legislature is aware of it, but the delegate who is introducing a bill to increase the cap certainly isn't. And the note in the 2005 amendment certainly makes it clear what the legislature was intending to do. Another factor when trying to consider this issue is that statutes should be narrowly construed so as not to make any change to the common law beyond what is expressly stated and necessary. It's well settled in Maryland that a plaintiff cannot ordinarily recover for emotional injuries sustained solely as a result of negligently inflicted damage to property. So if a plaintiff cannot recover them at common law for negligent damage to property, the passage of section 11-110, which does not provide for them, certainly cannot afford them to a property owner. All that the 2005 amendment did was give pet owners something they didn't have before at common law, nothing more. Statutes should be narrowly construed so as not to change the common law beyond what is expressly stated and necessary. The court has also said that whenever possible, an interpretation of statutory provisions should be given which does not lead to absurd consequences. To be frank, adopting the Court of Special Appeals interpretation of section 11-110 here would lead to absurd consequences because it would serve as a recognition in Maryland for the first time that a chattel owner can sue and recover for emotion-based damages resulting from a negligent destruction of property. It's important to remember here that the jury found that while this shooting was not justified and was a trespass to chattel, it was not committed with malice. It was not committed with ill will or improper motivation. Upholding the Court of Special Appeals interpretation would inherently include emotion-based damages for veterinary malpractice, for people who negligently hit pets with their cars. The effects of such a ruling here would be to open the gate to all types of emotion-based damages claims. Here, for example, in this case, there were multiple plaintiffs that were claiming they were affected by the death of this dog. Could anyone who experiences mental anguish, the loss of an animal, bring an action against the party who negligently killed it? What about other types of chattels? If the court recognizes a right to recover emotion-based damages for this type of property, why couldn't a person who has a genuine emotional attachment to a car or a beloved family heirloom recover emotion-based damages? Nothing in the law distinguishes pets from other types of chattel other than the right to recovery for fair market value and reasonable repair costs when tortiously destroyed. The respondent argues that pets are something more than ordinary chattel, that society is headed in that direction, and that may be true. And the day may come that the legislature declares that pets are recognized just like human spouses, children, and parents. But that day has not yet arrived. And speaking of the Wrongful Death Act, let's remember that prior to its passage, a person did not have a cause of action for damages for the death of their parent or their child or their spouse, even though the mental anguish that they undoubtedly felt was severe. It was the act of the General Assembly, the passage of the law, that created the cause of action, and notably only for the benefit of certain family members. So a person can bring a wrongful death action for their parent, spouse, or child, but not for their sibling, not for their grandchild, and not for their human best friend. It makes no sense that the legislature would provide for the recovery of mental anguish damages for animal best friends, but not human best friends. Until the legislature declares this to be so, the allowance of emotion-based damages should not be read by the court into the application of Section 11-110. I'd like to use the remainder of my time to speak briefly about the second question the petitioners have raised, and that's the sufficiency of evidence supporting a finding of gross negligence. This court has said it many times over and over again. Gross negligence is an intentional failure to perform a manifest duty and reckless disregard of the consequences affecting the life or property of another. Only conduct that is of extraordinary or outrageous character will be sufficient to imply this state of mind. Last year, this court decided Strachey versus the state of Butler, a case where there was no sufficient evidence of gross negligence, even though the EMT of first responders violated several protocols and their patient died. The court recognized that without evidence of any wanton, extraordinary, or outrageous state of mind to injure the patient, there was at best only big negligence, and big negligence is not gross negligence. The same is true here. Under these facts, there was absolutely no evidence presented at all in the few seconds between Officer Price hearing a door slam and turning around and seeing a large dog charging at him and making a decision to pull a trigger, that he could have formed the sufficient state of mind to reach the evidentiary hurdle that sets the bar for gross negligence higher than ordinary negligence. No evidence was presented that Officer Price violated any departmental policies like the EMTs and Strachey. In the brief, the respondent points to the fact that this dog was wearing a collar, so obviously Officer Price must have known that it was owned by someone, and when he shot it, he would be inflicting injury upon its owner. But that appears to be a total fabrication because there was no evidence at all that the dog was wearing a collar, and in fact, the parties stipulated in trial that the dog was not wearing a collar, at least in the photograph taken immediately after it was shot. That's in the record extract at 170 to 174. The court noted in Brooks that a plaintiff must point to specific evidence that raises an inference that the defendant's actions were improperly motivated. Here, remember, the jury answered the question, was this committed with improper motivation or ill will? No, they said. The respondent here could not meet the heightened evidentiary hurdle, and the trial court erred in allowing the question to even go to the jury. Nothing at all demonstrating that Officer Price was acting with an intent to injure Mr. Reeves when he determined, albeit wrongly, in a split second that his life was in danger and that he needed to act. Simply put, at most, this might amount to big negligence, not the heightened standard of gross negligence. No evidence of wanton, extraordinary, or outrageous state of mind of Officer Price was generated. No evidence of an intent to injure Mr. Reeves. No evidence of malice, no ill will, and no improper motivation. It's for these reasons that the court should reverse the Court of Special Appeals and remand this case to the trial court for an entry of an order vacating the finding of gross negligence and reducing the judgment to an amount no greater than $7,500 for the wrongful destruction of the dog. Thank you. I'll reserve the remainder of my time for rebuttal.
All right, very good. Thank you, Mr. Culpepper. Mr. Hansel.
Thank you, Your Honor, and may it please the court. My name is Cary Hansel. It's my honor to represent Michael Reeves, the owner of Vern, the dog that was shot in this case. First, the cap here only applies by its plain language to the fair market value of the pet and also the cost of veterinary care. The cap does not apply to the lost wages and other non-economic damages at issue in the case, and the plain meaning of the statute makes that abundantly clear.
Mr. Hansel?
Yes.
Excuse me. Do you agree that in Maryland we have compensatory damages and we have punitive damages, and those are the two categories of damages?
Not the way the statute defines it specifically, Your Honor, but outside of the context of this case and this statute as a general statement, that's certainly true.
Well, you would agree with me, wouldn't you, that ordinarily non-economic damages are a component of compensatory damages?
Outside of the context of this case and this statute, yes, Your Honor. But this case and this statute involve a very narrow statutory definition of compensatory damages. under section 11-110A2I, compensatory damages is defined as, in the case of a death of a pet, the fair market value of the pet before the death and the reasonable and necessary cost of veterinary care. When the cap says it applies to compensatory damages under this subsection, it obviously uses the definitions in the subsection, and the definition of compensatory damage is this very narrow band of damages. So that is all.
Wouldn't a reasonable interpretation of that language lead to the conclusion that the General Assembly is attempting to define compensatory damages as these two types of damages when you're dealing with damages to a pet?
Not given the statutory language, because it does not say compensatory damages as a result of the death of the pet are limited to or may only be. It's when defining the compensatory damages, the only place that word is used or that phrase is used in the statute is in connection with the cap. So it's being defined not as the only damage available or the universe of damages. In the context of the statute, compensatory damages is being defined in connection with the cap. So when you read that definition into the cap applies to vet bills and the value of the animal. Now, one reason we know that the legislature agrees with that interpretation is because, as Your Honor pointed out, since the 2014 decision in Brooks, there have been 4 legislative sessions and no attempt to overrule it. Now, Mr. Culpepper urges the court that even though Brooks was reported, that in some way the legislature ought not be charged with knowledge because it came from the Court of Special Appeals. But the Court of Special Appeals in Jennifer versus State Department of Public Safety and Correctional Services, 176 Maryland App 211, and Delmar versus Montgomery County, 169 Maryland App 187, 2007 and 2006 cases respectively, held that the legislature is also aware of its decisions. In other words, all the decisions of the appellate courts to the extent that they're reported, and Brooks certainly was. So the legislature has had 6 years and 4 sessions to make a change in the Brooks decision if it felt that one was appropriate. When we look at the I'm sorry.
Let me ask you another question, because I agree with you. I think we can agree that the language could be clearer. So when the court is looking for a logical reading of a statute, sometimes we look at other sections, and I'm looking at Title 11, which is the same section of the Courts and Judicial Proceedings, but in a wrongful death case, or I'm sorry, rather a personal injury action. In 11-108, you have the legislature knows how to define non-economic damages, and in that instance, there's a cap at $500,000. And so what I'm trying to figure out is, I know in this case we had the Local Government Tort Claims Act that provided a reduction, but I'm trying to figure out how your interpretation is logical, and the hypothetical I can think of is in a medical malpractice case for a personal injury, non-economic damages are capped at $500,000. Under your interpretation, if there was a veterinary malpractice case, the non-economic damages could be $20 million under your interpretation. That seems like an illogical reading of this statute when you compare how the General Assembly has treated non-economic damages for personal injury as opposed to your interpretation, where you're saying we read in that they're permitting non-economic damages, even though it's not defined in the statute, to allow a great recovery for injury to a pet.
So Your Honor, there are a number of answers to your questions. First of all, Mr. Culpepper's baseline presumption that the common law doesn't provide for non-economic damages is not accurate. So we start with the perception that the legislature needn't say anything. The legislature doesn't grant us our right to damages. Those damages arise from common law. There has never been a Maryland case stating that non-economic damages are not available for the death of a pet. Mr. Culpepper's cases are limited to cases that define animals as chattel without talking about the damages associated, or that say that there is no non-economic damages for inanimate objects. So
Is
You
there,
agree-
excuse me,
Oh, go ahead,
I'm
go
sorry.
ahead.
Is there a case that says there are non-economic, a cause of action for non-economic damages for a pet injury?
no, it's an issue of first impression, but the modern trend in states around the country is to rule that there are such damages. So for instance, Pennsylvania, Texas, Florida, Hawaii, Idaho, Kentucky, Louisiana, and New York, in cases in our briefing, all allow for such damages.
By common law?
In the vast majority of those cases, yes. I think 2 of the states I listed did it by statute. The rest are by common law, Your Honor. And that's the first part of the answer to Your Honor's concern. So that the common law in Maryland has never rejected these damages. The second part is that this is not a mere non-economic damages case. So there are economic damages in this case that exceed the value of the cap. If the non-economic damages were, and they're not being challenged other than through the application of this cap on appeal. So when I say the cap, the economic damages exceed the value of the Tort Claims Act cap, which is to say that if there were no non-economic damages available, no pain and suffering, then the economic damages awarded by the jury would still make up the full $200,000 of the cap. So even if Mr. Culpepper were correct that there was no pain and suffering as the result of a loss of a pet, a principle for which he can cite no Maryland case, and there is none, and the modern trend goes the other way, even if he were correct, the economic damages in this case would more than make up for the $200,000 verdict. They were awarded at $500,000, and they would.
Mr. Hansel, excuse me.
Yes,
What is your best position or best argument for the reason that the General Assembly would have left non-economic damages out of the statute if this term compensatory damages in its definition doesn't apply?
So because they wanted non-economic damages to be compensable. And when Brooks came out, they demonstrated that desire by not overruling Brooks.
But wouldn't it have been much clearer if they wanted it, non-economic damages to be compensable, to simply say so in the statute as they've done in other areas?
Your Honor, the vast majority of non-economic damages available to all of us as Marylanders have no statutory support. So our right to non-economic damages does not generally flow from the legislature. If I were writing this statute, might I write it differently? I'm sure Mr. Culpepper would write it one way, I may write it another. But the question for the court is whether anything in the statute specifically limits or ameliorates the otherwise availability of non-economic damages.
Do
So,
you
for
have
instance,
examples of any other areas where there's statutes that specifically define compensatory damages to economic matters, but parties are still allowed to recover non-economic damages?
I don't think the structure of any other statute is similar to this one. So for instance, other statutes modify pre-existing damages. Like for instance, Judge Booth brought up 11108 for the general pain and suffering cap, which that defined the limit of pre-existing damages. It doesn't allow, 11108 did not authorize or allow for the recovery of non-economic damages. They were permissible long before 11108 came into effect.
Well, then do you know
they,
of any other examples where the General Assembly then has put contours on non-economic damages that exist?
Of course, 11108 is an example where non-economic damages that were pre-existing were limited.
No, I mean,
and that's why, because the 11108 is a great example of why the statute works the way I'm suggesting it does. In 11108, because there were pre-existing non-economic damages available that the legislature wished to limit, it applied a limit specifically to non-economic damages, which must be done affirmatively in the statute. Here, there is no affirmative mention of non-economic damages. In fact, the statute is narrowly subscribed only to the value of the pet and to the medical bills. So 11108 actually demonstrates why this is the correct reading in conjunction with the Court of Special Appeals failure to make any changes in the 6 intervening years, and in conjunction with the history of the development of this statute. So another answer to the concerns being raised by the court is that the 89 and 99 versions of this statute did do what Your Honor suggests and did lay out a more clearly enumerated list of damages. There were then efforts in 01 and, I'm sorry, Your Honor.
Excuse me, what about our case law? And I'm putting aside the Brooks case, but our case law and the common law, which we've clearly stated in Exxon, Dobson, H&R Block, that we don't permit mental anguish, non-economic damages for property damage. And is this dog not property? So how do you reconcile your position with the Court of Appeals case law in this arena?
Two answers. First, that's a moot and irrelevant issue in this case, because even absent non-economic damages, the economic damage award that was granted to Mr. Reeves, primarily for lost wages, not for vet bills or the value of the pet, not for vet bills or the value of the pet, which is what are capped. The economic damages were $500,000. Then everything was capped down to $200 under the Tort Claims Act, so that even if the non-economic award were wiped away in this case, the economic award, which is clearly available under the cases you're citing, Your Honor, would still justify the entire $200. So I don't think the court reaches that question in this case, because the question of whether non-economic damages are moot in a case where the full award is supported by the economic damages. Now, having said that, all of the cases that Your Honor just mentioned, or that Mr. Culpepper cites, involve the touch on damages, or the question of non-economic damages, involve inanimate objects. It is the reality in the world today that there is a fundamental, emotional, almost spiritual difference between life, between a pet, an animal family member, and an inanimate object, like a car or an iPod or those types of things. That's true for two reasons. First, it's just true emotionally. As Mr. Culpepper said, it's true in our hearts. And the law ought to follow that. So for instance, Anne Arundel County's police department actually has funerals for canines that are lost. It doesn't have funerals when a car gets in an automobile accident or a piece of police equipment is lost. In connection with one of those funerals, Anne Arundel County issued a statement that said, "Our hearts are heavy and thoughts and prayers are with Bodie," that was the dog, "and his partner, Corporal Sanchez, during this difficult time. He was loved by his police and home family more than we can express." Anne Arundel County's police department loves its animal family members. All of us do. They are not mere inanimate objects, as a matter of fact, and this court has never limited the real non-economic damage that we feel at the loss of an animal family member in any reported case.
Excuse me, that sort of takes you to the analogy to the Wrongful Death Act. So if somebody's brother is wrongfully killed, you don't get non-economic damages for that, do you?
Here, this claim is brought on behalf of the animal's owner. So the owner is much more analogous to the class of people under the Wrongful Death Act who would recover. Animal owners frequently refer to themselves as mother or father. They call their animals their fur babies. The reality of modern treatment of pets is that the days of owning chattel to plow the field are long over. People sleep with their pets in the same bed. They have their pets inside. They treat their pets as family members, and the court ought to recognize that. So in analogy to the wrongful death cap, which is a different statute, and none of those principles or definitions have been imported into this statute by the legislature in the 6 years since Brooks. But in analogy to that act, an animal or pet owner is much more akin to the class of people who can recover in that act if we were looking for an analogy. It's also, I think, important to recognize again, that the economic damages would suffice in this case. So I don't think the court needs to reach this question of whether non-economic damages are available. And looping back to this statute, the compensatory damages as defined and the limitation as defined is not defined as applying to non-economic damages. The statute does not say, for instance, that non-economic damages and economic damages, or that all damages are capped at $7,500. If it did, we wouldn't be here.
Mr. Hansel, it seems illogical to say we're going to cap those vet bills. We're going to make sure that they're no higher than $7,500. But the sky is the limit if you want to proceed with economic damages or non-economic damages for the death of your pet. That also seems illogical to me.
So Your Honor, first of all, if we reviewed the actions of the legislature for logic, many more would be overturned, to be blunt. Secondly, it is not a question, I think, without an answer, because the legislature has made clear in not changing the statute. Thirdly,
well, let me ask you another question about Brooks, because the way I read Judge Friedman's dissent, he seems to be indicating, and that's why I asked Mr. Culpepper, that there might be a different analysis if you were talking about constitutional damages versus non-constitutional damages. Couldn't another reading of what the General Assembly has done or not done since Brooks is maybe they were interpreting Brooks as applying to constitutional damages and this statute applying where you don't have a constitutional issue?
Nothing in Brooks is limited to constitutional issues. Nothing in the language limits Brooks to constitutional issues. There's no discussion in the case that would support that analysis, Your Honor. I understand there is a dissent in the present case. It's not one that the defense went to any great pains to defend here, because the language in the dissent or the attempt to make a distinction between constitutional claims and other claims just simply falls flat under Brooks. I also want to address Your Honor's concern that in some way damages here are unlimited or uncapped. That isn't true. That isn't the case. So in all cases that have been mentioned by the defense and that I can imagine, there are other caps that apply. So for instance, this case is a great example. Even though the $7,500 cap doesn't apply, the $200,000 Tort Claims Act cap does apply. Likewise, in a case of pain and suffering, the 11108 cap that Your Honor has made reference to would apply in other cases. So there are caps that do lay over top of these claims and these types of damages in every case, every example that I can think of. So there isn't this parade of horribles or this threat that suddenly vets are endangered or anybody else is endangered, because there are caps that apply anyway. And this case makes that point by applying the $200,000 cap applicable to the Local Government Tort Claims Act. I'm not here to argue these claims are uncapped. I'm here to argue that the killing of an animal family member is not subject to the $7,500 cap that by the language of the statute is specifically limited to the loss of the value rather of the animal and also the vet bills. So it's not a free-for-all. And what we have seen—
What cap would apply to my veterinary malpractice?
At 11108, at the very least, Your Honor. So for instance, 11108 caps pain and suffering as a result of torts, and so that would apply. At the very least, I'm not an expert, frankly, in veterinary medical malpractice, nor is that issue before the court. In addition,
that statute applies to a personal injury action. I thought that the underlying claim here was a negligence action arising from trespass to chattels.
So, Your Honor, if you look at 11108, I think its interpretation is that it is broad enough to apply without drilling down to the entire statute, to apply to that situation of veterinary malpractice. If it doesn't, that's an issue for the legislature. It's not an issue for the court. It's also not before this court. In addition to all of that, there is a finding here on which the court could distinguish those types of claims if it wished, and it is the finding of gross negligence. Here, a very high standard was met. Now, it's not so high as the defense would urge. Here, the standard for gross negligence that was met was utter indifference. So this is not a case that is analogous to a veterinary malpractice case. Instead, here, the jury found an intent to inflict injury or action with such utter indifference to the rights of others as if they don't exist. So that's a very high standard. And the court could, if it wished, limit its holding in this case to a claim for gross negligence, which, after all, is what the facts of this case involve. Counsel mentions that a single legislator seems to misunderstand the effect of Brooks and the effect of the statute. Obviously, one legislator is not the entire legislature, number one. Number two, that legislator was obviously misinformed because for the last 6 years, Brooks has permitted for the recovery of non-economic damages. So that is not a good indication, I think, of legislative intent.
Mr. Hansel.
Yes, Your Honor.
There are opposing arguments about the plain language of the statute and opposing arguments about the meaning of the statute's legislative history. Is there a tiebreaker?
I think there's an easy tiebreaker, and that is the Brooks decision and the legislature's failure for 6 years and 4 legislative sessions to act to change it. And so it's very simple. And this court and the Court of Special Appeals have held that reported decisions of the appellate courts are presumed that the legislature is presumed to be on notice of these reported decisions. And this court has repeatedly held that the legislature's failure to act, given enough time, and 4 sessions certainly is agreement or acquiescence with this court's ruling. Agreement or acquiescence with this court's ruling. So the cites for that are Plain versus Department of Labor, 369 Maryland 421, Allen versus State, 402 Maryland 59, and PYE versus State, 397 Maryland 626. Those are 2002 and 2007 cases, so they're of relatively recent vintage. So
Mr. Hansel, have there been any cases where the court has made that holding where we're dealing with a Court of Special Appeals opinion as opposed to a Court of Appeals opinion?
The Court of Special Appeals has made such holdings, Your Honor. Those cases are Jennifer versus State Department of Public Safety and Correctional Services, 176 Maryland App 211. That's a 2007 case reported. Delmar versus Montgomery County, 169 Maryland App 187. That is a 2006 case, which is also reported, obviously. So the Court of Special Appeals has so found, Your Honor. I'm not aware of a case where this court has, but if you look at this court's opinions holding that appellate proclamations are presumed to be, that the legislature is presumed to be aware of the appellate proclamations, there's no limitation on those rulings. I don't think those rulings are fairly read as only the legislature only looks at our rulings. In fact, if Brooks was the massive sea change that Mr. Culpepper and Amici say it is, then certainly the legislature would be aware of it, and certainly there would be opportunities in the intervening 6 years to change it. So I think that, in answer to Judge Watt's question, is ultimately the tiebreaker. I think the second tiebreaker is the fact that there is no common law in Maryland denying non-economic damages as a result of the death of a pet. There are cases saying a pet's chattel. There are cases saying there are no non-economic damages for inanimate objects, but none for a pet, which everyone treats differently. So there's not—
Mr. Hansel, I know your time is running short. I was hoping you could respond to the points made in the amicus brief that we've gotten from a broad array of organizations, industry organizations and pet lovers. And if you could give us your response to the concerns. They say that your position is not the pro-pet position.
Yeah.
What do you make of that brief, please?
Your Honor, I doubt very seriously that any significant group of pet owners who love their pets retained that law firm and had them file that brief. So it is not, those folks, respectfully to them, do not represent in any fair or meaningful way pet owners. There's one pet owner before this court. It is Mr. Reeves, whose dog died in his arms while he tried to save it. I will also tell you that what amici claimed to be a 50-state survey touches only on 35 states. In 6 of those states, non-economic damages are permitted in certain circumstances. In 6, they involve animal injuries caused by other animals, so they're irrelevant. 3 are unreported and have no precedential value, even in the states from which they come. 2, Illinois and California, have been overruled. In 2 cases, the plaintiffs in the case didn't even attempt to argue non-economic damages. In 1 case, involved an attempt to claim emotional damages for the death of an animal the person didn't own. In another case, it was 90 years old and ignores the modern trend. And finally, the court rejected emotion-based damages, not because they weren't recoverable, but because those alone would not permit a negligence claim in another case. So when those cases are backed out of that analysis, it is the minority opinion, in fact, that has anything relevant to say across the case law about where we are now. More importantly, the modern trend is to recognize the reality of the loving bond between pets and their owners. And it is the goal and purpose of the law to reflect true justice, what we find in our hearts. And that, in fact, is, in this case, to permit for recovery. And Pennsylvania, Texas, Florida, Hawaii, Idaho, Kentucky, Louisiana, and New York, in the modern trend, have also held, as has Maryland in the Brooks case for the last 6 years, which has not caused any parade of horribles, as amici suggests. It has not been terrible for pet owners, as amici suggests. It has not given rise to a industry of claims against for veterinary malpractice. There are not monster verdicts in these cases. None of those things have come to pass. The counsel, defense counsel, who's gone well beyond the record to provide us with citations to legislative history and other things, has not made anyone aware of a single pet damage case in the 6 years since we had the Brooks decision from the Court of Special Appeals. So this parade of horribles just simply doesn't exist and hasn't materialized. The pet owner before this court urges the court to permit for damages and to recognize that pets are animal family members. And I think any reasonable pet owner would do the same. I understand that there are lobbying and other forces that may well want to visit the legislature and point out that this statute does not does not address the issues that they think it does. Finally, very briefly, I see my time is running out, but to touch on gross negligence, here, the officer claimed he was attacked. The jury found he wasn't. The forensic evidence showed that his version of events was completely false, that there was no justification for the shooting. Firing not 1, but 2 rounds in a residential neighborhood on a Saturday at 4 p.m. in the afternoon is grossly negligent. It is far above the standard where mere paperwork in cases like Catterton or Newell met the standard. This man is firing a gun at an animal that is no threat. The evidence showed could not even get higher than his waist. Counsel relies on this question of a collar, says it's completely fabricated. On page 236 of the record extract, when the Marine who owned this animal ran out to perform CPR, he says to perform CPR on his dog, he ripped off the collar. Ripped off the collar. That's in page 236. That is why when there were pictures taken of the dead body later, there was no collar. That's a clear fact in the case. And I would simply ask the court to affirm the jury's findings and also not to cap the damages to a mere $7,500 for beloved pets in Maryland. Thank you.
Thank you, Mr. Hansel. Mr. Culpepper, you have reserved, I believe, 10 minutes.
Thank you, Your Honor. First, with respect to the argument that the economic damage award is enough to uphold this entire award, even if the non-economic damages are not permitted, it's both economic and non-economic damages are a type of compensatory damage. And this statute defines compensatory damages for a specific situation. As Mr. Hansel points out, section B2 of the statute is the cap. And it says the damages awarded under paragraph 1 of this subsection may not exceed $7,500. Well, what does paragraph 1 say? Paragraph 1 says a person who tortiously causes the injury or death of a pet is liable to the owner for compensatory damages. Well, what does compensatory damages mean? In this section, it tells us the definition in this section of compensatory damages means fair market value and reasonable and necessary vet costs. So if we delete the term compensatory damages from section B1 and insert the statutory definition, the correct statement of the law in this statute is a person who tortiously causes an injury to or death of a pet is liable to the pet's owner for fair market value and reasonable and necessary vet costs. That's it. Not lost wages, not pain and suffering, not mental anguish, not loss of companionship. I concede in my heart, I feel that those things exist when a pet is negligently killed. I'm a pet owner myself, but the law doesn't permit it. And society may be trending in that way. There may be a national trend, but it's not up to the court to make the law. It's up to our legislature, and they've considered the issue. And they've defined. In fact, when they were contemplating raising the cap, I believe in the 2005 amendment, you can read the legislative history in our appendix. They were considering the fact that other states do permit non-economic damages, yet still defined compensatory damages as only fair market value and reasonable vet costs. Remember, this is an expansion of what a property owner would get at common law. If your car is negligently injured by a negligent party, you are entitled to reasonable repair costs. But if your reasonable repair costs exceed the fair market value of your car, you're going to get the fair market value, not more. It's different now for pets because of this statute. And if the legislature had wanted to include other types of compensatory damages, it would. It didn't, and that's why the law needs to be applied the way it's written. I also want to point out, Mr. Hansel says, it's the reality in this world that animate objects are more important than inanimate objects. That may be true. But why would, for example, a tree that I own and plant and have a bond with, if someone negligently destroys that tree, it's alive just like a dog, why would non-economic damages flow from that? Finally, I want to touch on Brooks v. Jenkins one more time. Judge Booth asked Mr. Hansel about veterinary malpractice. Mr. Hansel told us that Brooks was not limited to constitutional torts only. I want to read a passage from Brooks, which is found on page 471 of the opinion. And it says, we express no views on CJ section 11-110's reach in other circumstances, such as whether it reasonably would be construed to cover veterinary malpractice cases or product liability cases or other similar situations. We hold only that it does not limit the Jenkins's total recovery for the constitutional tort to the capped value of their pets' bills. So I think we have a different agreement on what Brooks says, but that's the quote that I'm going to rely on. And finally, unless the court has any other questions for me, I don't have anything else to say.
All right, well, we will see. It appears there are no further questions. Thank you, Mr. Culpepper. Thank you, Mr. Hansel. The court's proceedings for the day conclude with the ending of this argument. So thanks once again.